For the speed of 100 words per minute English shorthand. Start. The duty of taking minutes is one which falls to the lot of the secretary of every description of undertaking or institution, and no matter whether the secretary be in the service of a company or a municipal or other local authority, or of a charitable or philanthropic institution, his duties in relation to the preparation of minutes will be very much the same in every case. Before we proceed to a consideration of what are the best methods of preparing minutes in the case of a company registered under the Companies Act, it will be well to pause for a moment to consider what minutes really are and what are their objects and their uses. Answering these questions, we may say that minutes are the official record of the business transacted and the decisions arrived at by a meeting of the directors or of the members of a company. There are two reasons why these minutes are kept. The first reason is that the minutes of a meeting, when signed by the chairman of that or the next succeeding meeting, are evidence until the contrary is actually proved that the proceedings of such meeting were properly conducted. The second reason why minutes are kept, and it is a particularly cogent one, is that they must be kept. Section 120 of the Companies Act 1929 compels every company to cause minutes of all proceedings of meetings of its members and of its directors to be entered in books kept for that purpose. The minute books of the general meetings of a company have to be kept at the registered office, and during business hours must be open to inspection by any member without charge, in order that the business of the company may not be unduly interfered with by the members' right of inspection. The company can impose reasonable restrictions as to the time during which the minutes may be inspected, so that not less than 2 hours in each day is allowed. A member is also entitled to be furnished with a copy of any minutes at a charge not exceeding 6 pence for every 100 words. Refusal to permit inspection of the minute book, or failure to send a copy of the minutes within 7 days of a request to do so, renders every officer of the company, which includes any director, manager, or secretary who is in default, liable to a fine of £2 and a further fine of £2 for every day during which the default continues. In addition, the court may make any order to compel inspection of the minute books, or to direct that the required copies be sent. Stop.